SRIRAM's IAS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this concept class number 8. We are going to come up with a new concept for you for your upcoming prelims examination. Let's check what is the concept. And the concept is equality in opportunity in the matters of public employment. Public employment. So we all know state is a model employer, and for that reason it cannot discriminate on the basis of religion, race, caste, sex, place of birth, residence and descent when giving employment to the people. So equality of opportunity in public employment is given under Article 16 of the Constitution. So this is one of the facet of right to equality. We have already made videos on article number 14, right to equality, equal protection of law and equality before law, and then article number 15, prohibition on the basis of prohibition of discrimination on several grounds. Okay, several grounds of religion, race, caste, sex and place of birth. This was about equality before law and equal protection of law. You must watch these two videos. And now we have come with article number 16, very important for you to understand for your upcoming examination. Now, if you see article number 14, it is a broader concept which is extended not only to the citizens but also to the aliens. Equality before law and equal protection law are provided to everybody who are in the territory of India. Article 15 particularizes it. Article 15 gives several grounds such as religion, race, caste, sex, place of birth, and there shall not be any kind of discrimination on these grounds by the state. So this is article number 14. This is article number 15. Now article number 16 again particularizes article number 14 and then article number 15 as well. This is what is article number 16 because it deals only with public employment. Article 15 is a bit broader. So when the state is making special provision under article 15 for SC, for ST, for OBC or for women and children, they can be made in several sectors. But under article 16, those special provisions are only made in the matter of public employment. I hope you understand why article 15 is more broader and article 16 is a little narrower. And both of them particularizes article number 14, which is a broader concept of equality in India. So coming to the next slide, article number 16 in a nutshell talks about equality of opportunity in the matter of public employment. Equality of opportunity in the matter of public employment, and there shall not be any kind of discrimination on the basis of religion, race, caste, sex, descent, place of birth and residence by the state in a nutshell. Okay, now let's talk about the equality of opportunity and the several exceptions given to it. Now if you see article number 16, it has 6 clauses. There are 6 clauses. Clause number 1 and clause number 2 talks about the basic idea of article number 16. What is the basic idea of article 16? This is the basic idea, that there shall be equality in the matter of employment, in the matter of opportunity for public employment, and there shall not be any kind of discrimination on the basis of these grounds. This is the basic idea. Clause number 1 talks about the equality in opportunity in public employment, and number 2 talks about the grounds. So here clause number 1, it does not, but this is very important for you to understand that clause number 1 does not provide the right to employment, but it gives the right to equal opportunity. It gives equal opportunity in the matter of public employment. There's a difference between right to employment and equal opportunity. Right to equal opportunity in employment, the whole meaning changes here. Okay, nobody can claim employment or reservation as a right. It is the policy of the government. It is a special provision made by the government for the upliftment of the society, for making society more equitable. But employment cannot be asked as a right. Okay, the reservation, I would say, employment through reservation cannot be asked as a right in this regard. But equal opportunity in public employment, of course, this is the basic fundamental right against the state. Clause number 2 talks about several grounds on which the state must not discriminate while giving the employment. So yeah, these are the two grounds which talks about the basic idea of article number 16. Now what about clause number 3, clause number 4, clause number 5 and clause number 6? These are the exceptions. We have read about exceptions in article number 15. Okay, that there are two basic article number 1 and clause number 1 and clause number 2 in article 15, which talks about prohibition of discrimination, and several places are written which are public places and access to them are available to all, and there shall not be any kind of discrimination on the basis of religion, race, caste, sex, place of birth in the matter of access to those general public areas. And then rest of the clauses are about the exception, that special opportunities can be given to women, special provisions can be made to scheduled caste, scheduled tribe. Similarly, in article number 16, those two clauses reflect the basic idea of equality of opportunity in public employment, and clause number 3, 4, 5, 6 provides the exception. Now we are going to see what are the exception. So these are the exception. If you see, requirement of residence for employment or appointment to be made by the parliament. Now see here, clause number 2 talks about few grounds on the basis of which discrimination cannot be done, and one of the ground is residence, that on the basis of residence the state must not discriminate in public employment. But in several areas residence can be made as a requirement, but the law for that has to be made by parliament. It cannot be made by the state legislature, for the simple reason that state legislature is always under the local pressure to give more employment to the resident of that particular state. It may infringe or hurt or will be against the unity and integrity of the country, and for that matter, for that reason, only parliament is given the power to make law to make residence as a requirement in public employment. This is exception, and this is given under clause number 3. Okay, now the next one, clause number 4. This is another exception to the basic idea of article number 16, which is providing reservation to backward classes of citizen. And when you say backward classes of citizen, it includes the scheduled castes and scheduled tribe. So clause number 4 of article number 16 is the basic provision in the constitution for reservation in public employment. Okay, this is providing reservations to backward classes, and it was there originally in the constitution, and when they said backward classes, they included the scheduled castes and the scheduled tribes in it. With coming of the Mandal Commission, the other backward classes, which were around 52% of the country, the total population of the OBCs are around 52%, and that is the reason why Mandal Commission has said that 27% of reservation needs to be extended to OBCs, and which was extended by the VP Singh government in 1990. We are going to see that in the next slide. But when the provision was added, this clause was added in the initial stages of the constitution, the backward classes of citizens include the scheduled caste and scheduled tribes. Now, this is 4A. This is very important. Clause number 4A, reservation to scheduled caste and scheduled tribes in promotion. No reservation in promotion is provided to other backward castes, but is provided to scheduled caste and scheduled tribe. It is very important for you to understand. This is also a facet of equality. In order to create equality in the society, brute definition of equality before law cannot be used. There has to be some sort of affirmative action. There has to be some sort of equal protection, so that an invisible hand of the state comes to help the backward society, so that there is not any sort of perpetual inequality in the country, and for that reason help is required, and reservation comes in the way of help by the state, so that the these community can be represented more and more for their own development in the public employment. Clause number 16 4b, this is another one. It talks about the left out vacancies that shall not be clubbed with the 50% vacancies next year. For example, let's understand this with an example. If this is year 2022 and this is year 2023, so let's say there was a 49.5% reservation provided in 2022, but the eligible candidates were only less, and only 45% of the seats were filled. Okay, now the leftover seats, 4.5% leftover seats, what will happen to them? They will be carry forwarded in the next year. But this year also 49.5% of the seats have to be reserved. So this 4.5% of the seats will be treated as a separate class, will not be treated within this 49.5%. This will be treated as a separate class, and the reservations will be given to them. This is clause number 4b. Now clause number 5, 16. Clause number 5 talks about religious qualification for appointments. So if there are several institutions where the qualification of a person to be the head of that institution or to be the member of the board, the basic qualification is religious, then exception is given. If you see the basic idea in clause number 2, religion cannot be the basis of discrimination. Okay, but exception is given when the qualification of a person to be the head of that institute or to be the member of board is religious, and this usually happens in religious institution. It does not happen in secular institutions. I hope you get it. This is a very important exception to article number 16. And then the last one, article number 16, clause number 6, which provides reservation to economically weaker section, has been added recently. So from clause number 3 to clause number 6, what we see is the exceptions, whereas clause number 1 and clause number 2 tells about the basic idea of equality in opportunity in the matters of public employment. Now let us talk about several developments which have taken place in this particular case. So the Indira Shawnee case of 1993, also known as the Mandal Commission case. So the Mandal Commission was set up to study the reservations to the other backward classes in India. The Mandal Commission has come up with a figure that 52% of the population of India constitutes of the other backward classes, and for that reason 27% of reservation has to be extended to other backward classes. And this particular recommendation was implemented by the VP Singh government in 1990. A case was lodged in the Supreme Court against this particular action of the government, and that case was the Indira Shawnee case. That is why it is also known as the Mandal Commission case. This was the case of 1993, and through the judgment of the Supreme Court, several ideas came up which were implemented. But those ideas were also, not all, but many of them were turned around or were overturned by the subsequent amendment by the Parliament, and let us see what were these. So according to the Indira Shawnee judgment, caste may also be constituted as classes. That simply means the reservation were always meant to be given on the basis of class. Caste was also considered as a class. Caste, earlier it was said that caste cannot be the criteria to give reservations. But in Indira Shawni case, Supreme Court accepted that caste also constitute classes and hence reservations can be given on the basis of caste, because Mandal Commission has extended 27% of reservation to OBCs, and this particular case justified that reservation by saying that caste can be the basis of giving reservation. It has also introduced the creamy layer concept, that simply means that several people of the OBC, and this creamy layer concept has been extended only to OBC. It does not apply to SC or ST. It does not apply to scheduled castes and scheduled tribe. We have seen that promotion, reservation in promotion applies only to scheduled castes and scheduled tribes, and it does not apply to other backward classes. But when it comes to creamy layer concept, that applies to other backward classes and not the scheduled caste and scheduled tribe. So according to the creamy layer concept, if this is the whole other backward class and there are few people, this top people, economically and socially, if you see, they cannot be called as backward, neither historically nor educationally nor socially, then these people will be considered as creamy layer, means they are above the creamy layer, they falls under the creamy layer and they will not be getting the benefits of reservation. Okay, this is a very important thing for you to understand, the creamy layer concept. And everybody who is falling below this line, they will be getting the benefits of reservation. Okay. Now, another thing said by the Indira Shawni judgment is reservation should not exceed 50%. Now, that is what is said by the Supreme Court, that the ceiling has to be 50%. Denying the carry forward rule. See, we have already seen the carry forward rule here. This 4.5% seats which cannot be filled in the year 2022 has to be carry forward in the year 2023, and it does not matter it is going or exceeding the 50% limit, because these seats are of the previous year, they are not of this year. Okay, so they cannot be added in this 49.5% and can be said that this is exceeding the 50% ceiling given by the Supreme Court. These 4.5%, the carry forward rule, this particular seats, leftover seats, are considered as a separate class and then are filled in the next year. So the carry forward rule was not allowed in the Indira Shawni case. Now, this particular provision was overturned by the 81st Constitutional Amendment Act in the year 2000. Okay, this was overturned. No reservations in promotion. So, Indira Shawni case has said that there shall be no promotion, no reservations in the promotion even to SCs or STs, or for that matter OBCs. But this was also overturned in the 77th Constitutional Amendment Act in 1995, and promotion, reservation and promotion were extended to the scheduled castes and scheduled tribes. Okay. There is another concept of consequential seniority which was added by the 85th Constitutional Amendment Act. Consequential seniority simply means that if a candidate of scheduled caste or scheduled tribe is promoted and he becomes senior to the member of the general category, he will remain senior throughout their life, throughout the life of their duty. I mean, like if the, let's say 25 years of duty is left, the person who has been promoted from the scheduled caste and the scheduled tribe above the general category, and because of that promotion he becomes senior to the general category candidate, he will remain senior for the leftover period of 25 years. That is what is consequential seniority. It was added by 85th Constitutional Amendment Act. Okay, so this is what is the basic idea of Article 16, the basic idea of equality of opportunity in public employment. There are two clauses which tells about the basic idea, tells about the grounds on which there shall not be any kind of discrimination, and there are several exceptions made. So thank you very much for joining me in this video. We will come up with the next lecture on a very important concept. Bye bye and Jai Hind.